Los Angeles of California is the global hub for film and international business. After Washington, D.C., Atlanta, and Dhaka, Rajulo has inaugurated its fourth branch in the Little Bangladesh area near downtown Los Angeles. The office is located on the 12th floor of Central Plaza on Wilshire Boulevard. Rajulo is a full-service immigration law firm providing American immigration support all over the world through Google's state-of-the-art cloud technology. We stand out with a dedicated team of 7 accomplished attorneys and over 100 law clerks and case managers. Rajulo is your trustworthy destination for 100% accurate and reliable immigration service, ensuring your data security and peace of mind regardless of your location. We are proud to announce that our success rate is above 99%. To learn more about our Los Angeles branch, please contact the address and phone number shown on the screen.
Hello everyone and welcome back to the weekly live session held by attorney Raju Mahajan and Associates. For today's live session, I am your host Isabella Rosario, and we have none other than Mr. Raju Mahajan, the founding attorney of our firm, as our special guest for today. Mr. Mahajan, it is a pleasure to have you here.
Thank you very much, Isabella. Thank you very much for all the audience who are watching our show at this moment and will watch in our other social media in future.
Thank you so much. And yes, thank you to all of our audience members who have tuned in to our weekly live session. For today, we have a very exciting live planned. We will be having a very enlightening session on Child Status Protection Act from Mr. Mahajan. Mr. Mahajan, please tell us about it.
Thank you very much. Can I see the slides? All right. Thank you very much, everybody. So this is a very little complex topic, and many of our clients, they ask about this. So before we go detail, I just want to make sure that you understand this is a mathematical calculation. If you are not good in mathematics, it will be a little harder for you. This is a pure mathematical calculation. And also, I'll not go detail about like what is CSPA. I am assuming that you already know about CSPA, and then you're going to watch this video. Otherwise, a lot of things may not make any sense to you. Next slide, please. Okay, so what is CSPA? In short, like the purpose of CSPA is to protect certain children from aging out. So let me talk a little bit about what is CSPA, what is aging out kind of things. So in the family-based immigration petition, a lot of children, family-based immigration petition, sometimes it takes long time. Sometimes like it takes like a 14, 15, 25, 26 years to complete a application from beginning to end. So of course, there's a lot of dependents. They're very young child when they start the process, but when the process ends, most of the child, they pass 21 year. So in American immigration law, a child is defined anybody who is unmarried and under the age of 21. So if you're married and if you age out, meaning if you cross the threshold of 21-year-old, then you are automatically get rid of from this immigration benefit. So this is a big issue for many families. That's why Congress tried to like solve this issue. Of course, they could not 100% solve it, but they tried their best. So this CSPA is a way to calculate your age to keep it under 21 if it is possible. So to do that, you can deduct two period of times from the entire from your age, and by doing that you can you can be eligible under 21-year-old. So we will go to that calculation and see how to I'll try my best to explain it in a plain English. It's a mathematical calculation. Sometimes it maybe a little harder for you to understand, but I'll try my best. Next slide, please. All right, as I said, 2 time periods can be deducted from your age to see if you are under 21-year-old when you go and face the interview in the embassy or USCIS. Number 1, before the approval of the application. This one is comparatively easy. And when I say approval of the application, I do not mean the end of the application. I do not mean that you are getting your green card. Approval of the application means when somebody apply I-130 for you or for your parents, somebody, so USCIS at first will send a receipt notice, meaning they received your application, like your relatives application. There's a receipt notice, and after sometime few days, sometime few months, sometime few years, they will approve the I-130. It doesn't mean that you're getting green card. They are just approving the I-130. And so before approval of that I-130 application, you can deduct this age. And then once your immigrant visa becomes available, like almost end of the process, then you can also deduct another time from your age. So we'll go that detail later. First, we'll talk about the before the approval of the application. Next slide, please. So, excuse me, I have a little cough. Sorry for that. So you can deduct the gap between receipt date and approval date. Let's say, here there's an example. Let's say your relative filed application in January 12, 2021. So you get a receipt notice in, let's say, January 12, 2021 or 13, 14, 15, like within few days. And then finally, USCIS approves that I-130 in August 25, 2023. So there is almost 2.5 years gap between these two dates, priority date and receipt date. So you can deduct this time from your age. And by the way, here, approval date minus receipt date. There's a dash in between. This dash is like a minus. It's like a approval date minus receipt date. So in this case, approval date is August 25, 2023 minus January 12, 2021. So this age you can deduct from your age. Next slide, please. All right. How about after the immigrant visa becomes available? And this become available is a tricky term. I'll talk about this. So this is, and in this kind of situation, there's two scenarios. Number one, in the embassy, meaning consular process, meaning let's say your relative applied for I-130, I-130 got approved, and you and your parents, you live in a foreign country, let's say in India or Pakistan or Nigeria, and then once your case goes to NVC, and then documentarily qualified, you just keep waiting. At one point, your priority date will be present in the visa bulletin. So if it is in the embassy, meaning consular process, then age freezes when your priority date becomes current in the final action date for family sponsored preference cases box. So I assume you already know about visa bulletin. So in the visa bulletin, there's two major categories. One is for family-based application, one is employment-based application. In the family-based application category, there's another two boxes. One is called final action dates for family-sponsored preference cases. Another one is date for filing. So for the purpose of consular process, for the purpose of embassy, your age will freeze when your priority date is current in the final action date box, not the other box, final action date box. So let's say your priority date is current today, and then your interview is 1 year from now. So even though you are waiting more than a year after your priority date is current in the visa bulletin, your age will freeze today. So you can deduct this age from today to the date of interview. So your age will freeze today. This is for the scenario of embassy. Next slide, please. However, if your case is in the USCIS, so this is the most complicated part of the CSPA calculation. So if you and your family member, you live in America, and your I-140 got approved long time ago. Now this is time for I-485. In the scenario of USCIS, the appropriate form is I-485. If you file I-485, if you or your family member, then the applicable term is becomes available. So this become available can either be final action date or date for filing. I just told you that there's two boxes under family-based categories. One is final action dates, another one is date for filing. So it can be either of those. So how do you know? So there is a page in USCIS website. It's called Adjustment of Status Filing Charts from the Visa Bulletin. Adjustment of Status Filing Charts from the Visa Bulletin. If you go to that page, USCIS will tell you which chart they are following for the purpose of determining becomes available. and they will tell about the current month and the next month. So which chart you will follow will be determined by the USCIS at the time. So you cannot predict upfront. USCIS changes this thing every month, so you have to check your visa bulletin every month. I know it's a lot of hassle, but this is the work you have to do to get the green card. So, number one, CSPA is complex. Number two, this part, especially if you are applying for I-485, adjustment of status from within America, your age will freeze when your visa become available, and when the visa will available can be either of the two boxes, and it will be determined by the USCIS in that month. I'll give you another example very soon. Next slide, please. Okay, so now, I try to make it like a mathematical rule, kind of like a summary of these two situations. Number one, you can deduct approval date minus receipt date in the upfront. That is applicable to all scenarios. And then in the second scenario, if it is IVP, immigrant visa petition or consular process, then the mathematical rule is today's age minus when your priority date becomes current in the final action date box, minus, and then this part is within the bracket, within the parenthesis, within the bracket. So you have to minus it first and then minus from other age, minus approval date minus receipt date. I'm saying again, today's age minus when your priority date becomes current in the final action date box, and minus approval date minus receipt date. And if after all this calculation, if it is within 20-year-old, if you're under 20-year-old, then you are qualified for green card. I know it's just a little complex. Now let's go to the second scenario, which is adjustment of status I-485. The rule is today's days when immigrant, today there should be like apostrophe. Yes, I'm sorry, there's some typo here. Today's days minus when immigrant visa becomes available. Again, this visa available depends on the USCIS every month, minus approval date minus receipt date. So this is the calculation. It's hard for me to explain without getting more data, but this is the rule. So that was our presentation about CSPA, Child Status Protection Act. I hope I tried my best to make it clear, but if you have any question, I'll be happy to answer.
Thank you so much, Mr. Mahajan, for that enlightening piece of information. I'm sure we all have learned a lot over here. We already have some comments lined up. A question has popped from Mr. Rian Binte Kamal, and he asks, Assalamu alaikum. I am currently in a non-STEM program, master's, and in spring 2024, I will be doing my graduation. And in fall 24, STEM MBA or master's, I'm interested in getting admission in. However, this person has a few questions. The first question is, if I choose a non-STEM master's program, if I don't utilize that and instead do a STEM master's MBA program, will that be possible?
Yes, so a lot of things is possible. It depends on you. You can choose any subject, any university, any program. It depends on you. And of course, if you want to transfer university from one university to another university, that is also possible. But you have to talk to your school. You have to talk to your school DSO, and they will be able to guide you according to their policy. Every university has their own requirement, especially if it is a for-profit university. They have their own requirement. So talk to your school DSO and ask this question to them. They will be able to guide you. But answer from me is yes, you can transfer from one university to another. You can transfer from one subject to another subject. Everything is possible.
Thank you, Mr. Mahajan, for that response. Mr. Kamal has sent in another question, which is, if I graduate in spring 24 and I start off from fall 24, what should I do in the months in between?
Spring and fall. So, okay, the summer time is not considered as academic time. So let's say you graduate in May of 2023, and then you start another program in August 2023. These 2-3 months you can be unemployed. You don't need to go to any school or something. This is a non-academic year, so you don't have to do anything in this time.
I hope that answers your question, Mr. Kamal. Dear audience members, we have a few more questions from our archive emails. So let me read out the questions from the archives. The first question comes from a client named Zahid Hassan, and he asks, I hold a B1, B2 visa, as do my family members. We will visit the US together, and I want to shift to F1 status via premium processing. My query is the changing status for all three. Do I need to pay premium fees for each? As a main applicant, if I pay premium fee, can my dependents use regular fee for premium status?
No, yeah. If you want to do premium processing, you have to pay premium processing for all of the family members. And if you want to choose like a regular process for all of the family members. But you cannot choose like only premium process for you, and your family members will automatically get premium processing. That is not going to happen, because every application is a different application. You are going to change from B1 to F1, and your family members will be B1 to F2. It's a totally different visa category, totally different form. So you have to pay premium process for all of the family members.
I hope that answers your queries, Mr. Hassan. We have another question from Mr. 𝗦𝘂𝗍𝗄, and he asks, I had a F1 visa and arrived in the US, but US immigration revoked my visa and deported me to Bangladesh. How can I resolve this situation and return to the US with an F1 visa following US law?
Yes, so first we have to see why they, revoked your visa and they deported back to your home country. If there's any valid ground, then you have to resolve that issue. Let's say there's a very common issue. Let's say you applied you got the I-20 for the fall 2023, and then later you changed your you moved your admission from fall to spring of 2024. But you forget about that. So you try to come to America, and in the American airport, they see that your admission is for the spring, not fall. So then they may deport you back. So in that scenario, you have to get a new I-20 from your university, try to enter again. So short answer to your question, we have to see the reason for deportation. And if it's a valid ground, we have to solve that issue, and then you can try to come back again. If they did some mistake, if the deportation was not based on a valid ground, then we can take action against ICE or USCIS or anybody who was involved with this deportation. So we need to see the reason for your deportation.
I hope that answers your query, Mr. Hossein. We have another question from Mr. 𝗦𝘂𝘍𝗆 Chaudhary, and he asks, if I plan to shift from B1, B2 to F1 visa status within the US using premium processing. If the USCIS denies my status change, will my B1, B2 visa automatically be void? Note, I hold a 5-year multiple entry B1, B2 visa currently.
No, if your change of status from B1, B2 to F1 get denied, your B1, B2 visa will still be valid. There is no reason to be scared or afraid, because your B1, B2 visa will be valid. However, if they approve your change of status, then your B1, B2 visa will be invalid, and your new visa status will be F1. So don't worry, your visa will be valid.
Mr. Chaudhary asks another question. My second question is, if my change of status case to F1 is approved and then I visit Bangladesh, do I need to obtain an F1 visa stamping on my passport from the US consulate in Dhaka for my return to the US?
Yes, because no organization, no authority in America has authority to issue a visa stamp in your passport. So you can change off your status from B1, B2 to F1 from within America. Once you are in F1 visa status, if you travel back to Bangladesh or any country in the world, when you try to come back, you need a valid visa stamp to enter through the airport. So yes, you have to get a visa stamp from Bangladesh.
Mr. Chaudhary has one final question. If I apply for change of status within the US, or if my change of status is approved and my son applies for an F1 visa in Bangladesh, could it negatively impact his visa application?
No. Your application and your children or application is totally different, independent of each other. Everybody's application will be based on its own merit. So no, it will not be impacted.
Thank you, Mr. Mahjan, for your response. We have another question from Mr. Abdullah Al Mamun, and he asks, what are the grounds and procedures for asylum seekers denied by the court or the Board of Immigration Appeals to file a petition for review with a federal court?
Can you please read the question again?
What are the grounds and procedures for asylum seekers denied by the court or the Board of Immigration Appeals to file a petition for review with a federal court?
It depends on the background. It's very hard to say, answer this question because every grounds for review is different. Like we see, if it comes to me, I'll read your entire case. I'll read your original asylum application and how your attorney and the DHS attorney, they argued in the court. I'll read the entire transcript and I'll try to find some mistake, especially if there's any mistake from DHS's side. I'll try to show that DHS did some mistake, or judge, he or she misunderstood your scenario or something like that. I'll try to find some loopholes, if I say that, and then I will ask for review in the federal court. But it depends, really depends on your case.
We have one final question from the archives by Mr. Muhammad Almas, and he asks, I am in South Africa on temporary asylum status. I entered unlawfully and can't travel until my asylum is approved, but I can go back to Bangladesh. If I apply for an EB3 visa, then can I interview in South Africa or Bangladesh by the American Consulate Office?
So it's a very complex question. So since you are an undocumented person in South Africa, you will not be able to face visa interview in U.S. Embassy in South Africa, because anytime U.S. Embassy takes interview of a citizen of a third country, then the embassy needs to see your valid status. Since you do not have a valid status in South Africa, you'll not be able to face interview in South Africa. But you can go back to Bangladesh, and then you can face visa interview in U.S. Embassy Bangladesh. There is no problem with that. And my understanding is that since you are undocumented in South Africa, American authority will not know about this. So there will not be a big issue if you go back to Bangladesh and try to come to America through EB3. However, there is no guarantee that your visa application will be approved. So there will be a little risk of getting denied anyway. So these are the scenario.
Thank you so much, Mr. Mahajan, for responding to all of our archive emails. We have another comment from Mr. Rian Binte Kamal, and he says, if in the US any student transfers their SEVIS twice, afterwards in getting green card or NIW, will there be any problem?
No, there will be no problem if you do transfer of your service in a legal way, in a formal way. Then there will be no problem at all. However, a lot of time people do like a lot of mess ups. So my advice to all the people like you is try to be as formal, as procedural possible, because otherwise the more complex you will make your case, in the long run it will cost you valuable time. So the short answer is no, there will be no problem, but try your best to be as straight as possible.
Thank you, Mr. Mahajan, for that response. With that, we are done with all of our comments on the live and also our archive emails. So before we end it, I want to ask you, are there any immigration updates for us today?
Yes, so there are a few good updates. So a lot of time, our clients want to talk to the USCIS in person because of many reasons. So USCIS recently launched a new form for individuals like our clients, attorneys, and accredited representative to request an in-person appointment in their local field office for ADIT stamps. Like, the ADIT stamp is a kind of like a stamp, emergency advance parole, immigration judge grants, and many other reasons. So this is a very good tool about the new form. Another good news is, not good news, sorry, this is a bad news actually. Another news is former President Donald Trump, he disclosed his immigration plan if he gets reelected. Of course, everything is up in the air. This is a future statement, but he is very restrictive. His immigration plan is very restrictive for future immigrants. So I'm not going that detail into the immigration plan, but I'm just saying he disclosed his plan if he get reelected. So those are like very short immigration update for this week.
Thank you so much, Mr. Mahajan, for enlightening us. Thank you, our audience members, for being with us till the end of the session today. We hope to see you next week at the same time on the same day. Till then, stay well. Thank you so much, and goodbye.
Los Angeles of California is the global hub for film and international business. After Washington, D.C., Atlanta, and Dhaka, Rajulo has inaugurated its fourth branch in the Little Bangladesh area near downtown Los Angeles. The office is located on the 12th floor of Central Plaza on Wilshire Boulevard. Rajulo is a full-service immigration law firm providing American immigration support all over the world through Google's state-of-the-art cloud technology. We stand out with a dedicated team of 7 accomplished attorneys and over 100 law clerks and case managers. Rajulo is your trustworthy destination for 100% accurate and reliable immigration service, ensuring your data security and peace of mind regardless of your location. We are proud to announce that our success rate is above 99%. To learn more about our Los Angeles branch, please contact the address and phone number shown on the screen.